Yeah. Firstly, Lulu may join the call later. So, in case she does, I will.
Yeah, sure.
Secondly, how cool is it to have someone who knows everything on your side, Peter? So they're fucked. I mean, so badly fucked because, firstly, it shows that they are very concerned and, you know, they're desperate enough to try and block the evidence from being filed. Now, I was drafting a very long formal correspondence with the citations. There's just no basis for what he's saying. Like, I have the things memorized by heart. Firstly,
I'm sorry. Yeah, sorry to interrupt. I didn't mean to interrupt. I was just sort of saying. But in the place of it, I mean, he's making a judicial decision, isn't he?
not just that, he's not providing any reason. So, first, he says that this rule says that I can reject it if it's vexatious or frivolous.
Yeah.
And I deem that it's vexatious or frivolous, and that's why I'm rejecting it. Without providing any basis for substantiating why he says that it's vexatious or frivolous, or what part of it is vexatious or frivolous. Okay? Now, here's the thing. What he's referring to is about the lodgement of documents, not evidence. That's the first thing. Okay? The definition of vexatious in the authority that he's referring to, basically exclusively applies to proceedings. So it's proceedings that can be unfairly oppressive, that can abuse the court's process, blah, blah, blah. Here, the application has been accepted for filing, but the evidence in support, he's rejecting it. So it's stupid. If anything can be vexatious, it's the application and not the evidence that will substantiate it. Do you understand?
Yeah, no, absolutely. I
completely stupid. And then what he's saying about frivolous, that fanciful, no prospect of, to the extent that it could ever apply to evidence, then what he's talking about is the probative value of the evidence. Okay?
Yeah.
Firstly, that's a judicial decision, exclusively, under the Evidence Act. Secondly, the admissibility of evidence is exclusively determined by relevance and not by its probative value. For the purposes of determining relevance, you consider the probative value to be at its highest. It's after that the probative value criteria starts coming into consideration. And here's the thing. There's so many things here. Firstly, if evidence is relevant and it's admitted, even if it is abusive, the other side has to take objection, otherwise it will be used. Okay? There's even a thing called the Bunning's discretion, or sorry, I think it's the Bunning, not with the plural. Bunning discretion. Basically, what it sets out is that even where the evidence is unlawfully obtained, like someone breaks into someone's house and steals their documents and then tries to use them, and 1 second. Lulu?
Hello? Yeah.
I was talking to Peter.
Yeah.
I'm gonna join you. Peter?
Yeah. I'm here.
I'm gonna merge Lulu. Okay, so you're both here. Lulu, I was telling Peter about the stupidity of the email that they've sent. But basically, firstly, the rule that he's talking about, it applies to applications, not evidence, because an application is vexatious and not the evidence in support of it. Here they've accepted the application and not accepted the evidence in support. Secondly, the frivolous aspect goes to probative value, which is not relevant in terms of admissibility, it's only relevance. And thirdly, it's a judicial determination anyway. There's very well established criteria for that. Now, the other part is that I was telling Peter about the Bunning discretion. So even if the evidence was improper or scandalous or whatever, ultimately the court has to exercise the discretion about whether adducing it will further the public interest more so than rejecting it. So this is particularly relevant where, for instance, the police commit crime to catch or to gather evidence about criminals, and then the court has to consider which crime is worse. That's the Bunning discretion. It's also called the Ireland discretion. Lulu knows about it at least because she raised it with Gunay previously in relation to the search warrant. Not that it presented any evidence of crime against anybody, but anyway, it was about whether or not they can even argue that in the circumstance. Then the other part is that there's literally an authority of the court, and I had found to hang the prothonotry of the Supreme Court with, but here's the thing. It's a full court of the Federal Court Authority from 2018, and it says that it's called Nyoni versus Murphy to 2018 FCAFC 75, and at paragraph 33, the purpose of a rule such as Rule 2.26, which is the rule he's relying on, is to assist the registrar to maintain efficient operation of a registry, and they cite an authority in support of that. It is in the interest of the administration of justice that there be procedural requirements to be met in order for an application to be brought before a judge of the court and for other parties to be required to attend. Procedural law deals with the means and instruments by which courts regulate the conduct and relations of courts and litigants in respect of litigation itself. Then they cite authority for that. Compliance with rules as to practice and procedure is usually adjudicated rather than dealt with administratively. Compliance with rules as to practice and procedure is usually adjudicated rather than dealt with administratively. However, some aspects of procedural law are carried into effect administratively without any judicial determination. Okay. Subject to provisions within the Federal Court Act with respect to practice and procedure, the practice and procedure of this court shall be in accordance with the rules of the court. They cite the section of the Federal Court Act that says that. In particular, the rules of the court may make provisions for or in relation to the practice and procedure to be followed in registries of the court, blah, blah, blah. The rules of the court have the force of law as rules of procedure and practice. They deal with the means by which substantive rights may be enforced in the conduct of court business and may not go so far as to make, alter, or remove substantive rights. They cite authority for that. The power conferred by Rule 2.26 is to be contrasted by a power of the kind considered in another authority where the registrar was required to form an opinion whether an application was frivolous or vexatious or prima facie could not be made out, and if that view was formed to refer to the matter to the President for adjudication after giving the applicant a reasonable opportunity to satisfy the President to the contrary. If blah blah blah, that's not relevant. Okay. In this court, registrars may act judicially or administratively. They act judicially when they are given powers basically by delegation. They act administratively by exercising powers validly conferred by the rules of the court or under the rules of the court concerning the procedure to be followed in registries. For reasons we have given, the power conferred by Rule 2.26 is not a judicial power being exercised under another provision which gives delegated judicial authority. Under Rule 2.26, the refusal of acceptance of the document means that the matter is not brought forward for any adjudication. In those circumstances, a registrar acting under Rule 2.26 does not have power to adjudicate under the substantive law whether an application that a party seeks to bring is an abuse of process or is frivolous or vexatious. The registrar has no judicial power to determine substantively whether a claim must be dismissed because it is an abuse of process or is frivolous or vexatious. Rather, Rule 2.26 is the means by which an administrative requirement is expressed that all documents filed in the registry must not in their form and content, in brackets, irrespective of any substantive assessment of their merit, be an abuse of process of the court or frivolous or vexatious. For reasons we have given, we are satisfied that the registrar, okay, then not relevant. So basically, what they're saying is that, so in that case, what happened is the party was basically referring to a rule of the court through which orders can be amended because it's a slip or whatever. And the registrar basically said that that particular rule did not apply and dismissed the application, and the party said, well, it wasn't for the registrar to decide because blah blah blah. And the court said, no, they can decide that. So a rule of slip is basically where there is an obvious error, which is a clerical error made by the judge on the face of the order. And it's not about whether or not, they made a mistake because they misjudged the matter or were misled or all of the other, fraud-related arguments or whatever else. So it's just basically whether whatever order was made, there was a typographical error in it. So the registrar said that that rule was not applicable to the way in which the party was bringing the application. So the court said that it can do because it's basically a purely grammatical interpretation or pure simple English language interpretation, and not an evaluation of a judicial character about whether or not the proceeding will be oppressive or blah 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 blah. So it's they're just fucked up, like so fucking fucked up, because there's two problems with it. Firstly, if they take that position, then the application is vexatious or frivolous or whatever. The evidence is not. I mean, because the application is seeking what it's seeking. The evidence is either relevant or not, and if it's relevant, then it's excluded by other criteria under Part 3.11 of the Evidence Act or not. So, and I mean, we're giving evidence of what we discussed. It's totally not up to him to determine whether our discussions scandalize the affairs of the court, and therefore they should be removed. Do you understand what I'm saying?
Yeah, no.
It's just so desperate. Now, there's two things here in terms of what we can do. So all the authorities say that when this happens, so when the registrar refuses to issue proceedings, then you have to start a judicial review proceeding, is what the authorities say. And this is where the fucking preponderatory asshole, Supreme Court one, fucked up, because he didn't let us judicially review his decision. Do you remember? He rejected that because he said, there's a rule, blah, blah, there's a process, blah, 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 and you can only follow that, which is stupid. Anyway, I'll deal with him later. But this, I don't think that's applicable to us because the proceeding is already underway, and what we will rely on is the power of the court to regulate its own process, and we'll say that it's an abuse of process that the registrar is engaging in, and it's basically meant to stop us from filing evidence and blah blah blah. Also, the other problem is that I don't know how they can seal the application without the evidence, because it was an application for an urgent hearing. By rules of the court, it cannot be made without evidence. So I don't know on what basis they're doing that. In fact, if you remember, on the 17th of June, when I said, well, it's been emailed, for instance, so it's lodged, the application, the LSP people objected that, well, there's no evidence in support of the thing, so it should not be accepted. Now, we were relying on the evidence already filed, but, they were trying to take specious objections. And this one, the particular application we're making, it's not, no evidence has been filed before about that. So on what basis have they listed an urgent hearing? I mean, this is the problem with what Downs has done. It's clear that she listed the matter, and then the registrar had to basically accept the. So they have accepted the interlocutory application and rejected the affidavit, though they were filed as part of the same filing. And that's most unusual, to the extent that they couldn't even, visibly seal the document, because when it's rejected, the whole thing is rejected. So they've written and said that it's, even though the stamp doesn't appear, we have sealed the application, but the stamp doesn't appear because the whole filing has been rejected. Now it's clear that it's because Downs already listed the thing, so they had to seal it. But I don't know on what basis Downs listed the thing if she hasn't considered the allegations we're making against her. Because, all this while, she was never interested in listing the thing. So she's seen the allegations we're making, found them to be serious enough to warrant an urgent listing. Not just an urgent listing, but like go against her previous decision not to list it. And then she's basically denying us the opportunity to rely on that very fucking evidence that has changed her mind. So, if nothing else, the evidence is relevant for the purpose that we provided that to her, and only after that she listed the matter. And I mean, this is so fucking stupid, because I'm gonna give him a bunch of choice quotes from a number of authorities, but I'm gonna end this discussion with this. This is from R versus Hoser. It's a Victorian authority that quotes a number of other authorities on, people being highly critical of judges, and this was said in Nationwide News versus Wills. It's one of the preeminent authorities on criticism of the court and when it's justified. So Justice Brennan held at 38-39 that it would not be contempt to criticize court decisions when the criticism is fair and not distorted by malice, and the basis of the criticism is accurately stated. His Honor held that it would be for the public benefit if comment was fairly made concerning conduct that is truly disreputable, in the sense that it would impair the confidence of the public in the competence or integrity of the court. Justice Brennan held that revelation of, in quotes, truth would be for the public benefit if it constituted fair criticism based on fact, and that would be so even if the end result was that there would be less public confidence in a court or a judge. His Honor held that the laws of contempt do not suppress, in quotes, justifiable or fair and reasonable criticism, which exposes grounds for loss of official repute. So what the court did was it distinguished between people trying to, make scurrilous allegations to undermine public confidence in the operation of the courts, versus people attacking the conduct or action of a judge, whether it's in the performance of their official duty or outside. And what he said is that if people criticize a particular judge as incompetent or corrupt, then it's that judge's reputation that gets damaged, not the court's, if it's specifically pointed towards that judge. And then it's really a question of whether it's being done so as a tactic to prevent judges generally from dutifully judging cases, or because the person actually thinks that the judge is incompetent or corrupt. So if you apply a tactic that every judge in your matter, you will basically call them a moron or corrupt because what you've done is wrong and you don't want the court to decide it, then it's contempt of court and problematic. But if you genuinely feel that the judge is an idiot, then they don't have any fucking protection from criticism. Because, I mean, if anything, they should be criticized even more. Because there are very few jobs in which the statutory criteria says that you're not fit to hold the office unless you are, particularly competent and this and that. Do you know what I'm saying?
Yeah, no. It's everything you're saying. I get the basis of it, the gist of it, yeah.
Yeah, so we're going to write to. We're going to raise a constitutional notice about this particular matter. If she doesn't, if the court stops us from filing the evidence, we will raise a constitutional notice about this particular matter. This is like at the core of the. That case was a constitutional case that I'm talking about. It's one of the preeminent constitutional cases about, whether or not criticism of judges is fair, and so on and so forth. And we will raise a constitutional notice about this matter if they stop us from filing the evidence, because what they're doing is basically, this is another quote from a different authority quoted in Hosa. A democracy cannot exist without the freedom to express new ideas and to put forward opinions about the functioning of public institutions. Because of their very importance in a democratic society, the courts are bound to be the subject of comment and criticism, not all of which will be sweetly reasoned. Do you understand?
No. They can't. Yeah, it makes perfect sense that they can't do what they're trying to do.
No, and I mean, like, what if someone wanted to bring a contempt application against me? So all of that evidence would be relevant, wouldn't it? So if the evidence can, what 2.26 deals with is whether on its face the documents are problematic and cannot be accepted without an evaluation of how they will be used. Okay, so by the registrar's logic, that particular affidavit can never be accepted. Because that's the only decision he can make. He cannot make whether it will be relevant, which is a judicial decision, or any of the other stuff. So by that logic, if someone were to charge me with contempt, because in the recordings, besides all the other stuff, I've also said something which is completely, unacceptable, no matter what Justice Downs have done, then all of that is evidence against me in relation to the contempt charge, yeah? And it can be obviously filed with the court for the determination of whether or not I've committed contempt. Right?
Yeah.
So, if it can be filed for one purpose, then it can be filed for every purpose, because the determination of appropriate purpose in relation to evidence is a judicial determination. So, anyway, we'll file the thing, and I'll write I'm writing a very lengthy letter with all the authorities quoted, and they'll learn a lesson after this, because there's no one who knows more about this by now than I do, because of all the ways in which different court officials have been trying to, stop us from holding the corrupt officials to account. So, okay, I'll send that through, and then at the same time I'll advise them about availability, and then if she doesn't, I'll also say that, because it's the registrar who's doing it, right now we've not filed a notice about this particular issue, but if she adopts the registrar's position, then we obviously file a notice because she's doing it. And the other point is that because we're asking her to recuse herself, I don't think she should be deciding matters. Sorry? Yeah, I mean, she shouldn't be deciding what evidence goes in, against her, because that's like she's controlling what criticism can be made against her. And I mean, the other part is that she wants me to like play those things in court on the day. I mean, it will just be too long then. Do you know what I'm saying?
And when he obviously made the decision without even looking at everything. How can you make that decision? You would have had to look, technically, you would have had to have, one, you can't make that decision, and two, you would have had to have technically looked and read it all anyway, wouldn't you?
Yeah, he's not even identified which part of it. He's just saying it's just scandalous and frivolous. I mean, that is to say that a judge can never do what we're alleging that they've done.
Yes.
It's just so stupid because judges get convicted of every crime that exists. At some point in time, there will be a judge who would have committed, any kind of crime. So it's just, it goes on to show that they're not acting independently, and they're each party is covering for the other. So there's no fucking due process. Okay, so that's what we'll do. I think we can end the discussion now. Yeah?
Yeah, don't obviously, you want to ring on, we don't all that. Okay, cool.
Cheers, bye.
Bye.